Hello, Carla Hartley here. Today I am continuing my discussion of how not to cost yourself money in a family law proceeding. Alrighty, so today I want to talk to you about not getting married to the idea that you cannot engage in the adversarial process, that you must somehow find a way to settle your case. A lot of times we have this kind of behavior where one party is saying, oh my God, if you hire an attorney, you're going to lose everything. No, if you hire an attorney, probably the person saying you'll lose everything is the one that knows he has a lot to stand to lose if you educate yourself. So I'm going to be talking a little bit on the different psychological observations I've made about, I guess, some of these things. But first I'm going to talk about the 4 different types of mediation routes. Okay, let's start with just the JD. That's the guy who's advertising. He's advertising for the ability to mediate for you. And a lot of times we will see that this person has a licensed therapist, and this is the person who's been trying to save your marriage, but aw shucks, we can't save your marriage. So here, this person has a JD. Let's have him mediate this for you. He'll be very inexpensive. He will probably be inexpensive, or she. Now, just having a JD means this person has never passed the bar. Attorneys who have also got a JD, we've gone through law school, we have our Juris Doctorate degree. In order to practice law as an attorney and to have any experience practicing law as an attorney, you must pass the bar and be sworn in to the local bar association. You have to pass the MPRE, which is the board standard, the national board standard for making sure that you are informed of your ethical obligations to your clients. So this JD that has never practiced any kind of law at all, or has had the ability to practice law stripped from them by disciplinary practice, which is rare. Most often it's the person that thinks, hey, I know how to draft a contract, I can draft a settlement agreement. The problem with these people is you're going to pay them $1,200, $2,500. I don't think I've seen any of them even as high as $5,000. They get started, and these people have no real knowledge, and they have no real duty. They have no duty whatsoever to either party. They don't have a duty to ensure that the disclosures are completely done. They kind of step back and say, that's on you guys. You've said you've done your disclosures. We're all done here. And they don't have a duty to ensure that the community estate is distributed equally. They don't have a duty to ensure that the separate property estate of either party is preserved. They don't have a duty to make sure support is established per guideline. They don't have any duty whatsoever beyond their contractual obligation with you to get an agreement. Now let's talk about the psychology. The psychology of many mediations, and this is the one I'm talking about here. This is the guy or the woman who's got a lot of psychological control over the other side, and they have intimidated the other side into thinking, you cannot enter into an adversarial process with me. You will get nothing. You'll be poverty stricken, whatever. We'll lose everything. The lawyers will take it all. That is not the case, unless you have a really unethical lawyer. So you should look at reviews and see who you're going to hire before you hire them. The problem that we have here with this complete lack of duty, their job is to get a signature on an agreement. That's their whole job. And it's very easy, and it has been my experience and the experience of many people who have transited my office after entering into a type of agreement that was obtained in this way, that they deeply regret. And it was because one party was dominant, and you see the mediator in this situation does not have the skill or the obligation to stand up to the dominant party and ensure that there is an equal distribution of the community estate. It just, they let the parties negotiate in their presence, and the dominant party ends up getting most of what he or she wants. This is tragic in many cases. So how does this cost you money, you ask? This costs you money because if you have written proof of fraudulent misrepresentation or certain other types of evidence, you're going to end up hiring an attorney to say, oh, okay, we're going to set that agreement aside and try to work on it from another direction. The problem is you've cost yourself money by leaving a lot of money on the table or in the other side's pocket, and now you've cost yourself money because you've paid this mediator who is not necessarily skilled or educated and cannot practice law. You've paid this person, now you have to pay somebody else, a real attorney, to start over, or not a real attorney, an attorney, a licensed attorney, to start over, and to undo what you've already done, if possible. That is expensive. So we have a lot of people come in where I look at this and they've left, $30,000 to $40,000 on the table, but when we look at the burden of proof we're going to have to establish to right that wrong, it's going to cost that much in fees and costs, and there are so many protections for the mediation process that it's very difficult to set these aside. That's my warning about mediation with someone who has no duty to either party. And these people tend to be charming, so you can believe me or not on this. All right, this is number 2. The next type of person that we have to deal with here is going to be the attorney mediator. Okay, now there are mediators, there are attorneys who do mediate. And these attorneys will be very clear that they have no duty to either side of the case. This gets sticky, and I have looked at doing this myself. Our firm has looked at this. It just feels sticky. In fact, it feels like somehow there's a violation of a duty of loyalty to the client. You can't have both clients. You're dealing with 2 clients in an adversarial position, and you're trying to exercise a duty to both of them. It's impossible. As for someone of my temperament, certainly it is impossible because I am an advocate at heart. So you've hired this person, and this is a person who has not generally practiced family law or has not practiced it very long at all. But they do all kinds of agreements. They are an attorney. They have the ability to practice law, and they may even have practiced extensively in different types of civil proceedings. That does not mean they are qualified to do the issue spotting and make sure that the duties of disclosure and all of the other rights and obligations have been met between the parties, because you do not have someone who is obligated to you. They're obligated to the 2 parties equally. This is a big step up from the mediator who does not have any qualifications really to be mediating beyond the fact that they attended law school. Now, you still have the same problems. There's still that protection over a mediated agreement, but now it's even more difficult to break through those protections, and you can still end up leaving money on the table. My best example for a disaster on this, a gentleman came in well over 2 years after the mediated agreement, and this person had agreed to pay spousal support forever. There was no termination date put into the agreement. This is something that should be on everyone's checklist, but it was not. And after multiple attempts to put this aside, he had been unable to do so and ended up with us. And we could not get the evidence that would permit us to do this, to help him get a termination date for spousal support. So we passed on that. This was horrific. Even after retirement, he does not have the right to stop paying this high amount of spousal support. There is no termination date. There's no circumstance under which this person can walk away from his support obligation, other than the other party's death or his own death. So that's a good example of how horrific a result you can have when you have a non-family law professional okay, or someone who is not a professional family law practitioner. And by professional, I'm using the Marine Corps definition of the word professional, which is mean this is internalized, this is a point of personal pride and obligation and professionalism. Okay, then we have two more types of mediators who are not going to run into quite that problem. There is the attorney mediator who's got 20, 30 years in practice as a practicing attorney in family law. He or she knows all the issues, they know the dirty tricks, they know the ways to conceal things, and they are very often going to be very, very pleased and will often insist that all disclosures be done before they get involved. They will often insist that even if counsel is not going to be present with the parties in the mediation session, they will want to make sure that nothing is signed until independent counsel has reviewed it. These are people who know what they're doing. We work with them often. More often, if we're working with skilled family law professionals, we don't need to go to mediation. We can determine what's going on, have a voluntary settlement conference or two, and start resolving issues and at least narrow the issues that the parties can't agree on. We can build a judgment from the ground up, starting with date of separation, and work until we have only one or two issues the parties cannot possibly agree on because there's a question of factor law that must be determined. So even then, the mediator can be a good option, and sometimes going to trial is a good option. All right, then okay, that's what I call the real deal family law attorney as a mediator. Now we have the retired judge or commissioner who has benched extensively in family law trials. Mediation is available with them, and very often this is under the same circumstances or very similar circumstances that you have with the seasoned real deal family law attorney who's taken on the mediator's role. So the bench officer who would be doing this for you is retired, and you will most often have them requiring that counsel be involved and that all of the disclosures are done. And the bench officer does have a duty to ensure an equitable distribution of the community estate, unless the parties really agree otherwise. And most times in this kind of thing, even if independent counsel isn't involved, they will require independent counsel to get involved if there's any appearance that this is not an agreement that does equally distribute the community estate, preserve separate property. The parties are knowing, voluntary, and intelligent when they make their agreements. So, how to save yourself money in a family law proceeding. If you have assets, if you have debts, you want to make sure that you are getting your value of the assets. You want to make sure that you are not getting the other side's value for the debts, unless you're getting assets commensurate with that. You want to make sure that you're getting an adequate support obligation, that they're not hiding income or misrepresenting their income. We do this all the time, and I will say the latter two types of mediators do this all the time, and we are quite good at it, and you will find that that money is very, very well spent. The first two, I have seen too many instances of regret. To be fair, I haven't seen everyone who has entered into an agreement in those two circumstances. I've only seen the ones that have discovered that they have been tremendously wronged, and I haven't even seen all of them. I'm sure they go to other people too. All right, you have a good afternoon, and I will be speaking with you again shortly. I hope this has been helpful.